Luke. Luke, can you hear me?
Yes, I can.
Okay, thank you very much. Well, good morning. My name is. Can you see me?
No, I cannot see
I don't know. I don't know
currently.
why, but you can hear me, okay?
Yes.
I don't know why. Wait a moment, because I don't know why you can. Sí, pero ¿dónde está la cámara? Aquí. Detener la grabación. A ver. La cámara, I have desactivar, no. Well, I am sorry for this, but you can hear me, don't you?
Yes.
Okay, so we are going to start. My name is Juan Manuel López Ulla. It's a pleasure to meet you. We have written to each other, but on several occasions, but this is the first time we see one another. Welcome, Luke, to the University of Cádiz. Even if it is in this way, online, we hope you will be able to visit our university in person soon, accompanied as well, if possible, by our dear friend and colleague Javier García Oliva, professor at the University of Manchester. And of course, Luke, thank you so much for accepting our invitation to take part in this research project and for speaking as a panelist at this Congress. If you agree, I will introduce you very briefly. I will do so in Spanish, and then I will hand over to you so that you can present your paper for no more than 30 minutes, if possible, please.
Of course.
We, as I told you by email, we would also be grateful if you could speak slowly so that we can understand you better, at least those of us whose English is not very good. After your presentation, we will have around 15 minutes for a discussion. Do you agree?
Yes, absolutely. Can I just check, is the subtitles working and translating as well?
We have here in the we have a PhD student that can help us. Okay. Bueno, nuestro siguiente ponente se llama Luke Graham. Él es profesor titular en la Universidad de Manchester. Es doctor en el Reino Unido. Es doctor por la Universidad de Lancaster. Su tesis doctoral llevó por título Destitution as a Denial of Economic, Social and Cultural Rights, Addressing Destitution in the UK through a Human Rights Framework, que podemos traducir más o menos como la indigencia como negación de los derechos económicos, sociales y culturales, abordar la indigencia en el Reino Unido desde un marco de derechos humanos. Por tanto, es un título muy sugerente. Su línea de investigación está centrada particularmente en los derechos económicos, sociales y culturales, y la dimensión socioeconómica de los derechos civiles y políticos. En relación con el tema que nos ocupa, en 2022, Luke Graham publicó en 2022 su tesis doctoral en la editorial Routledge. Y tiene varios títulos, varios artículos publicados en revistas especializadas, con los siguientes títulos: Charity and Statutory Powers to Alleviate Destitution, que tiene la sugerente traducción, si lo hago bien, de caridad y facultades legales para aliviar o combatir la indigencia. Tiene otro interesantísimo artículo con el título The Gatekeeping Function of Vulnerability in Public Law and Human Rights, que podríamos traducir como la vulnerabilidad como concepto determinante en el derecho público y los derechos humanos. O también podríamos citar otro que lleva por título The Cost of Living Permacrisis in the UK and the UDHR Rights, que podríamos traducir como la crisis permanente del coste de la vida en el Reino Unido y los derechos de la Declaración Universal de Derechos Humanos. Son títulos realmente sugerentes y sin más preámbulo le voy a dar la palabra, lamentando no tener servicio de traducción, pero al menos a lo mejor a través de la transcripción podremos enterarnos. Luke, the floor is yours.
Thank you very much. I would like to begin by thanking Manuel and the other people who will have been involved in organising this conference for the opportunity to speak today. I am especially grateful for the opportunity to present remotely. Due to my teaching commitments, I unfortunately have not been able to travel to join you in Cadiz. I would also like to thank those of you in attendance, and I'd like to apologise for the fact that I am presenting in English. I hope that the translation software is working well, and I hope that I'm speaking at an appropriate pace for those of you who are able to understand me. I want to speak today about how the essential needs of asylum seekers are met in the United Kingdom. And I hope that by doing so, this could be a point of comparison for other jurisdictions. So I hope it's interesting for you to learn about what the United Kingdom does when it comes to asylum seekers, and then I'm sure you'll be able to draw comparisons to some of the thoughts from other speakers. So, how will I do this? First, I'm going to give some context from the British system. Currently, asylum and refugee status and irregular migration is an incredibly high-profile and controversial issue in the UK. This means that our government has recently announced some changes, so I want to give you this context. Having given this context, I will then turn to explain to you how asylum seekers are currently provided for in the United Kingdom. So how their socio-economic rights are met, how their basic needs, such as housing, clothing, food, are met. And in outlining this system of support, I will explain that it is inadequate, that it does not realise social economic rights. Moving on from this, I want to suggest that in the context of proposed reforms in British law, the European Convention of Human Rights might have an impact, because this might limit the practical, the real life impact of some of the changes that the government are proposing. And so I want to suggest that the changes as they are proposed on paper sound more drastic than they will likely be in practice. I turn now to outline the support that asylum seekers receive in the United Kingdom. The United Kingdom draws a distinction between recognised between asylum seekers, recognised refugees, and failed asylum seekers. And different forms of support are available for each of these three categories. Recognised refugees who have been granted international protection, they are able to access the general social security system and they are able to work. Failed asylum seekers receive very limited support. My focus is on asylum seekers, so individuals who have claimed asylum but are waiting for the decision from the British government as to whether or not they will be granted asylum status. And so I'm focusing on the socio-economic rights of asylum seekers. These persons are ordinarily excluded from the general social security system. Instead, they are supported through a different system of asylum support. And today, I will be using the term asylum support to refer to this system. So I'm using that to refer to the support I'm about to outline. Now, currently, the British government has a legal duty to make provision to prevent asylum seekers from experiencing destitution. This means that if an asylum seeker is destitute, so if they are homeless, or they are struggling to access food or clothing or other essentials, if they are destitute, the British government has a legal obligation to support them. This duty flows from domestic law. It comes from an Act of Parliament. In November 2025, however, the British government announced plans to revoke this duty to support. Instead, this duty would revert to being a discretionary power. And this means that whilst the British government would still have the power to support asylum seekers who are facing destitution, asylum seekers would not have a right to that support. And so this is a watering down of the legal entitlement to support. This proposal is part of a package of reforms which are to be introduced by the current government. And they give several justifications for this in their recent paper on this topic. I quote, they wish to reduce the flow of arrivals into the United Kingdom. They wish to increase the removal of those who have no legal right to be here. They wish to secure British borders and to tackle, I quote, the asylum crisis. These changes to socioeconomic support are intended to ensure asylum support is reserved only for those who need it and comply with the system. So we have a government which is concerned about migration, wanting to limit migration, limit asylum, and so forth. And part of doing this is reducing the economic support which is provided to asylum seekers. Now, there are concerns about these proposals. This is a scaling back, a regression of socioeconomic support and of economic and social rights for asylum seekers. And this scaling back is occurring in a context whereby several organs of the United Nations have identified that socioeconomic rights are currently not adequately realised for asylum seekers in the United Kingdom. So the system is already insufficient and problematic, and yet the government is suggesting to make this system worse. In 2019, the United Nations Special Rapporteur on Extreme Poverty and Human Rights, then Philip Alston, identified that destitution appears to be a design characteristic of the asylum system. That it appeared that the system of asylum support in the UK was designed to force those reliant on this system into destitution. More recently, last year, the United Nations Committee on Economic, Social and Cultural Rights produced its concluding observations on the 7th periodic report of the United Kingdom's monitoring of the International Covenant on Economic, Social and Cultural Rights. That report made several recommendations relating to the socio-economic rights of those subjects to the United Kingdom's international protection regime. So I suggest to you that currently, when we are looking at this from a human rights-based perspective, there are clear weaknesses in the current system, and yet the government is suggesting to weaken this system of support. Now, in the United Kingdom, in contrast to many other jurisdictions, we operate ordinarily pursuant to a dualist model, whereby international legal obligations are not given direct effect in English law. Instead, the Parliament of the United Kingdom may legislate to incorporate international legal obligations into the domestic legal framework. And it is through such incorporation that international legal obligations become justiciable in domestic law. Most socioeconomic rights-based obligations have not been incorporated into domestic law. Consequently, such rights are not directly justiciable in the United Kingdom, and this means that asylum seekers are not able to use the International Covenant on Economic, Social and Cultural Rights, or the European Revised Social Charter, or other economic and social rights-based treaties to enforce entitlement to socio-economic rights. Now, even despite this, individuals may be able to enforce legal entitlements to the substance of some socio-economic rights. And this is because the Parliament of the United Kingdom has legislated to create domestic statutory entitlements which can satisfy the obligations flowing from socio-economic rights. And therefore, individuals might be able to indirectly, this is the key word, indirectly enforce socio-economic rights by directly enforcing statutory rights. So we have a domestic statutory right which can be enforced, and that will allow people to indirectly enforce socio-economic rights. I want to turn then, with that context in mind, to explain the current system of support for asylum seekers. So what domestic rights do asylum seekers have? Whilst their claim is being considered, asylum seekers are ordinarily excluded from the ordinary system of social security, and they are usually prohibited from working. This means that asylum seekers do not have any lawful way of supporting themselves except perhaps through a reliance on existing assets, such as savings, if they have them, or through reliance on charity. Instead, they are supported by an alternative system of support. And the legislator of the United Kingdom has placed public authorities under a duty to provide destitution relief for specified groups. Such duties to alleviate destitution are limited in their coverage. They protect only narrow categories of persons. These categories are, firstly, children, and secondly, asylum seekers. In the case of child asylum seekers, these two categories intersect, and it follows that both statutory regimes for children and separately for asylum seekers are relevant in understanding the socioeconomic rights of asylum seekers in the United Kingdom. The duty to provide destitution relief to children in need and their families is contained in Section 19 of the Children Act 1989. This would suggest that a child asylum seeker would be entitled to support under the Children Act, and that their family would also be entitled to such support. However, Section 122 of the Children Act 1989 prohibits local authorities from providing assistance to child asylum seekers and their families when there are reasonable grounds for believing that support may be provided under the general system of asylum support. Unaccompanied children seeking asylum are supported outside of the general system of asylum support. Unaccompanied child asylum seekers are protected by the Children Act. However, the Children Act regime does not apply to accompanied child asylum seekers, or in other words, it does not apply to adult asylum seekers and their dependent children. Unaccompanied child asylum seekers made up approximately 3% of all asylum seekers in the year between June 2024 and June 2025. So this means that 97% of asylum seekers in the UK fall under the general asylum regime rather than the system of the Children Act regime. And this means that they are supported, the vast majority of asylum seekers, by the regime contained in the Immigration and Asylum Act 1999. And this is the key piece of legislation related to the socioeconomic rights of asylum seekers in the United Kingdom. This is supplemented by secondary legislation, and together this is the regime which regulates the system of support for most asylum seekers. So I want to then explain what this regime entails, what it includes. In 1999, when this regime was first introduced, this gave public authorities a discretionary power to provide destitution relief. This meant that public authorities could lawfully support asylum seekers, but that they could not be required to do so through the courts. So this was not a right to support, it was instead a right to request support. This was the regime for several years. However, this discretionary power was transformed into a non-discretionary duty, by which I mean it became a right. Destitute asylum seekers now have a right to support, which they can enforce through the courts. And this duty was transformed through domestic secondary legislation, specifically Regulation 5 of the Asylum Seekers Reception Conditions Regulations 2005. This was a response to the Council Directive 2003/9/EC. This is the directive which is referred to as the Reception Directive. And this Reception Directive laid down minimum standards for the reception of asylum seekers. So we see here that European law, EU law, Union law, has influenced the system of domestic protection in the UK. It transformed a discretionary power into a non-discretionary duty. It is Section 95 of the Immigration and Asylum Act 1999, which forms the basis for a legal entitlement to support for asylum seekers or their dependents who appear to the Secretary of State to be destitute or to be likely to become destitute. And so an important element of entitlement is that only destitute asylum seekers can access this support. Entitlement to this support is contingent upon being recognised as destitute. Now, one barrier to accessing the support, upon which I have published already, is that if an asylum seeker can benefit from other sources of support, such as charity, then decision makers may determine that they are not destitute. So, for example, an asylum seeker is provided with a bed in a hostel by an organisation such as the Red Cross, which has happened in the UK. And because they are being provided with this bed by a charity, the government will say that that individual is not destitute, and therefore there is no power or duty to support that individual. This is despite the fact that charity does not adequately realise socioeconomic rights in the United Kingdom, and I published also on this topic and making that argument. So let us then imagine that we have an asylum seeker who is destitute. They are recognised as destitute by the government, and therefore they have a legal domestic statutory right to asylum support. What does this mean in practice? They are entitled to accommodation and cash support. Now, one thing to be aware of, which I know is a common issue across Europe, is that asylum accommodation in the UK is largely outsourced by the British state through the use of asylum accommodation and support contracts. And there's a small handful of private companies who have been awarded 10-year contracts, which began in 2019 and will end in 2029. And they have these contracts to provide accommodation to asylum seekers. Now, a recent review of asylum accommodation by a House of Lords Select Committee, so within Parliament, within our legislature committee there, they received extensive evidence describing poor quality and substandard housing across the asylum accommodation estate. The report found that while there is clearly accommodation of an acceptable standard, too many asylum seekers continue to be placed in accommodation that is inadequate or deeply unsuitable. As such, many asylum seekers are provided inadequate accommodation. Beyond accommodation support, Section 95 of the Immigration and Asylum Act entitles asylum seekers to a
weekly cash allowance. Now, this allowance is reduced if an asylum seeker is accommodated in full board accommodation. So if their accommodation provides their meals, they get less money per week. If an asylum seeker is provided meals by their accommodation, they are given £9.95 per week. Over the year, this is on average less than £45 per month, which is approximately €50 per month, and this is to buy all essentials other than accommodation and food. So this is to buy toiletries and to buy clothing, for example. So this is not a great deal of money. Now, not all asylum seekers have their food provided in their accommodation, and those who do not are given a higher amount of money per week. They are given approximately €56 per week, or roughly €3,000 per year. €3,000 per year to cover all of your basic needs other than shelter, to pay for food, clothing, toiletries, and other necessities that people need to participate in society. This system of support is widely regarded as insufficient. And therefore, so far, I have outlined that asylum seekers have a different system of support as compared to members of the general public. And I've outlined that this system of support is not very generous. Beyond these domestic entitlements to support, asylum seekers may also be able to access destitution relief through the European Convention of Human Rights. This is because positive obligations to make socio-economic provision may arise under this treaty. Now, these claims have succeeded only in limited circumstances and only in the context of international protection. And I will suggest to you that those seeking international protection are currently unique in having used Article 3 of the European Convention to enforce positive obligations to socio-economic rights. And there are two seminal cases in this regard. The first was determined by the House of Lords in the United Kingdom in 2005. The case of Limbuela centred on the legal regime applicable to late asylum seekers. So individuals who did not claim asylum as soon as they arrived in the UK were excluded from the ordinary system of support. And because they were not allowed to work and they had no other sources of support, the court held that this was a violation of Article 3. And therefore, the British government changed the rules so that these individuals were still provided some support. The other case from the Grand Chamber of the European Court of Human Rights is a very famous case of MSS. It was decided in 2011, and this concerned an individual who was expelled from Belgium to Greece under the Dublin regulation, and in Greece he experienced severe poverty. The European Court found that this was a violation of Article 3, and they attached, I quote, considerable importance to the applicant's status as an asylum seeker and as such a member of a particularly underprivileged and vulnerable population in need of special protection. Now, as both of these cases make clear, members of the general public will not be able to use Article 3 to force the government to give them destitution relief, but asylum seekers can succeed doing this. And this would suggest that the European Convention of Human Rights is more responsive to the socioeconomic deprivation of asylum seekers than it is to similar claims by the general public. But even then, the protection is limited. And in the UK, it's likely that a claim would not succeed unless an individual is excluded from asylum support. And this is where the fact that the government is talking about making the power discretionary interacts with the European Convention, because if this would leave asylum seekers destitute, it's likely that the government would have to provide support in accordance with the Linguela reasoning and also NSS, so under Article 3. I'll just make a final point, or a couple of final points to bring my presentation to an end. But asylum seekers are excluded from work and they are excluded from social security. They have an alternative system of support which supports destitute asylum seekers with accommodation and cash. Now, evidence suggests that both the accommodation and the cash support is inadequate. And this suggests that asylum seekers are not able to enjoy their socio-economic rights in the UK. Now, despite the government's proposals to change the duty to provide support, it's likely that destitute asylum seekers, who by definition lack other sources of support, will be able to use Article 3 of the European Convention to access asylum support. So thank you very much for the opportunity to speak. I'll draw my presentation to a close there.
Thank you. Thank you very much, Luke. We are applauding you.
Thank you.
Thank you so much for your interesting and clear presentation, in which you have highlighted the difficulties faced by asylum seekers in the United Kingdom. You have made it clear to us that in practice there is a big regression in the protection of the socio-economic rights of asylum seekers, mostly since the last year. This is the moment to ask the people in the classroom if you have any question for Luke. ¿Alguna pregunta? Tenemos, ¿la vas a hacer en inglés? You are going to speak in English or in Spanish? Okay, so we have the micro. Sorry, Luke, because you can't see us. I'm very sorry for that. Well, we have one question, okay?
Not a question, but I am sorry because I don't have heard your conference since the beginning. Is very complicated, this situation. In UK, I think is following the model Estados Unidos, Trump, no? Because United Kingdom have a good relation with Estados Unidos. I think they are following the same why, because don't like asylum, and if they are in consideration is same charity. but so many asylum don't leave his country, for economy, maybe for reason political and another. And this time is not clear what you don't want do with asylum. If one asylum don't have money for life, what he's doing? What is the response from the government? Thank you.
I don't know if do you have any other question for Luke. Si os da apuro el inglés, tenemos aquí una amiga que nos puede hacer la traducción. Nada. Well, look, this is the only question we made you. Well, I have one question, if you don't mind. I would like to ask you if does this position of the British government reflect the general opinion of the public, of the UK society?
Okay. Yeah. Thank you both for your questions. I think the person who spoke first was slightly more distant from the microphone, and so I didn't fully hear, but I think I got the headlines around in terms of if these people do not have money for life, what is the response from the government? Arguably, this is a deliberate design by the government. It's been referred to as planned destitution, and it's been designed in such a way as to make life very difficult for these people who the government really is trying to incentivize to leave the United Kingdom and to go elsewhere. And so the system is set up to not be very welcoming. It's set up to discourage people from wanting to continue with their asylum claim and then to instead go back to their country of origin, or instead perhaps travel to a different jurisdiction. And so I hope I managed to partly address the first question, and I apologise, as I said, it was difficult to hear, I think, because of the sound. And then in terms of the second question, thank you, Manuel, in terms of the position of the British government and then the position of the British public. This is an incredibly polarised issue, by which I mean there are some people who support the government and in fact will suggest that the government should go further and that the support should be massively reduced, because currently migration is the political issue in the UK. It is the biggest issue, and all the political parties are scrambling to respond to it. But on the other side of this debate, then, there's people in society who believe that the government should have a more humane system and that we should be better providing for asylum seekers than we currently are. But this is not the direction that the government is going in. It seems that the weight of public opinion is very much on the side of reducing the rights and the protections of asylum seekers. And this is very concerning. Ultimately, the British government, through Parliament, can do whatever they want here. From your perspective, we do not have the same constitutional protections that you may have in other jurisdictions, such as Spain, that place limits on the sorts of laws that the government will enact. And our government is therefore able to do almost what they will. That there are some retained elements of EU law which is still applicable here, but the government's recent report shows that they're trying to push back against this and to free themselves from the limitations of retained EU law, such as the Reception Directive.
Okay. Thank you very much. If there is no questions in the classroom, thank you very much, Luke. I am very grateful for the effort you have made. You speak very clear, so we understand you perfectly. I hope to see you soon here. Thank you.
Very much look forward to it. Thank you so much for the opportunity to speak today, and I hope the rest of the Congress goes wonderfully.
Thank you to you.
Okay.
Bye, Luke.
Bye now.
Bueno, pues sin solución de continuidad, pasamos a la próxima ponencia. Miguel, ¿podrías presentar ¿no? Bueno,
No sé qué decir, más que me considero un compañero estupendo.
Bueno, venga, pues lo hago yo. Es por no estar todo el tiempo aquí en la... Te dejo un momentito, déjame, Carlos, que...